Justice Carly, Mr. Justice, may it please the court. This case is actually, in one thing, very complex, but also very simple. And that is really set forth in Judge Murphy's order. This falls under the Strickland standard, ineffective assistance of counsel. We had an interesting set of facts leading up to this. Mr. Chapman was charged with arson that resulted in a lady's death. Ms. Hankins, who was his appointed to represent him, the second lawyer appointed to represent him in the from the Georgia Public Defender Standards Council, had a huge territory, covered a big chunk of the western part of the state. She effectively, in the motion for new trial hearing, said, I had about 16 days. Now, she didn't request a new trial. Another continuance. She'd been advised by the court that she wasn't going to get one, and she better be ready when it came back up again. Another thing that really sets this apart is Mr. Chapman repeatedly asked for a polygraph. All during the preparation. He said, please give me a polygraph. I didn't do this. I had nothing to do with that. I love this lady, and I had nothing to do with her death. Ms. Hankins' response was, well, I don't think we can get the money for that. It wasn't, well, in my discretion, you're probably not telling the truth. We don't want to do it. In my evaluation of the case, that ain't going to help us. Or she didn't even come out and say, look, we can't get it in. As we know, polygraph is not seldom admissible unless it's stipulated to in other situations like that. But I'm not bringing that up for the fact that he actually passed the polygraph, which he did.
After trial.
After trial. The point is, it was her duty to investigate. And that's where I think the confusion at the trial court actually came up and it's something as in the appeals I've worked on, I've tried to avoid, but this motion for new trial was extremely fact intensive. And that's not a good thing because you end up trying to retry the case. And I think that's where the confusion came in. If you look at Judge Murphy's order, he talks about the inadmissibility of the polygraph. He talks about various other factual situations that would be from the finder of fact. But in doing that, he kind of goes past and sort of glosses over the fact it's really not about these facts. It's about whether the justice was turned upside down because of defense counsel's failure to investigate the case. From the jurors, from investigating the jurors, there were numerous jurors that were had very close ties to law enforcement, but she didn't check it out. And there's comments in the order about, well, there were no affidavits from those jurors or anything. Well, that's really almost moot. The point is she didn't check it out.
It's not moot because you have to show not only a deficiency in not investigating, but prejudice.
Exactly.
So maybe it was deficient to not give him a polygraph, but what's the prejudice since polygraphs are inadmissible without a stipulation?
Except for the fact we have over and over in there, the district attorney and the assistant district attorney said, well, if we'd known there was a polygraph, we would have certainly at least had them re-administer a polygraph, would have probably completely changed at least the pre-trial proceedings. And we can't just look at the trial itself.
And Mr. Little, they backed off from that kind of, hadn't they? The state kind of backed off from saying all these problems, have they not? Or agreeing with you is what I'm saying.
Well, yes, sir. They sure have, Your Honor. But if you look at their reasons, reading their briefs and the judge's order,
right,
it's all basically a fact-based thing, which that's the purpose of the trial. A fair trial is going to get the right facts out. And it's our position that this trial wasn't fair because Ms. Hankins didn't do her homework, for lack of a...
To avoid getting new trials just by showing things weren't done well in preparing for trial, you also have to show that something would have been different. You had the opportunity in the motion for new trial proceeding to bring out whatever should have been done. And for example, for jury selection, you had the opportunity, if there were problems in the jury selection, to go lay that all out in the record, and the trial court found that that there were no affidavits from the jurors, and as far as I can tell, we don't know what. I mean, you say there were jurors with law enforcement connections, but what's the proof of that?
Well, we did have an investigator talk to all these jurors and found this out, and the investigator testified at the motion for new trial and told the judge what she had found. That there's a whole litany. There were 4 of them, I believe, that had very close law enforcement. And that's not going to be hearsay. She found out that Juror A was related to this person in law enforcement. Juror B was related to this person in law enforcement. Also found out that this particular pastor, there was the letter that came out, basically a confession letter, that wasn't objected to, was the pastor didn't even know this person. Those aren't even, it's not a matter of any kind of hearsay, things that would have been not brought up in trial. It's a matter of failure to investigate.
But okay, so you show a juror is related to a person in law enforcement. That wouldn't, if that came out at trial, that wouldn't get the juror off the jury.
Not necessarily.
You'd have to prove that the juror was unable to render a fair verdict and an impartial verdict. Did you do that with any of the jurors?
No, they didn't do anything.
Did you do that in the motion for new trial?
No, because that was,
Okay, well,
in Strickland, as I'm sure Your Honor understands probably way better than I do, you have the 2 prongs. You got to show that it's unreasonable, it wouldn't have been a reasonable lawyer would not have acted in such a way. And then you have to show that there was a high probability that it would cause a different outcome. And there can be, though the state of Georgia doesn't allow cumulative mess-ups, for lack of a better way to phrase it, but that kind of says it all.
Cumulative error is what we call
Cumulative errors, Your Honor. But you can look at things in the total picture. And when you start talking about investigation, you kind of have to look at the whole picture. You have to be able to look at whether the attorney was making decisions which would be strategic, or whether the attorney, and this is what Ms. Hankins said in the motion for new trial, it's what the evidence, all these particular things tend to show, is that she got caught trying a major trial with a lot of very specific evidence with not enough time to prepare, and she didn't ask for any extension. And one of the big and the key one is the polygraph, not because of what it actually said, but because of the negotiating tool that polygraph has. Many public defender's office, many times, I've tried a lot of criminal defense cases. I've personally paid for polygraphs. And I think many public defenders, Judge Murphy referred to it, many public defender's offices have someone to submit it, so they have that negotiating tool. She's basically going into a boxing match with one hand tied behind her hand.
But to prove that it would have resulted in a reasonable probability of a different result, you would have to have proof in the record before us that the district attorney said, had you brought that polygraph to me before trial, and I believed it, even though it was taken after trial, and my own experience as a prosecutor, polygraphs aren't so much good, and ones after trial aren't so much good for anything. But if you had brought that to me, I would have led to a different conclusion. I would have given a different plea bargain, even though your client says he's innocent. So why would we believe he'd take any plea? And that's the missing link here. Even if you can show deficiency, what's the proof of a different outcome?
The district attorney's statement, we would have handled it completely different. We would have at least investigated. We would have at least done our own polygraph.
Yeah, that doesn't, so we would have investigated and done their own polygraph.
And
why would that have been a different result in a trial that was held?
Well, with all due respect, Your Honor, you're asking to put the defendant on the plane where he has to be a prosecutor too. The defense can only handle his end of the field. In this case, when you have the prosecutor saying, we would have handled this differently, we would have done a polygraph. If that polygraph had shown the same as yours, we'd have been a whole different ballgame.
But that doesn't help you because
we can't make them.
If it's a speculative, had you taken a polygraph before trial and had that polygraph come out the same as the one after trial and had our polygrapher repeated that polygraph, we would have considered a different outcome, is not the result of the proceeding would in reasonable probability have been different. It's, well, maybe if lots of things had happened, something else could have happened.
But that's not what happened, Your Honor. We had a polygraph that showed that our client passed. The state said, well, we'd have done the same thing had we had any idea.
Okay.
So they're saying that's not speculative. They would have done it.
And then what would have happened?
We'd have had a trial based on no polygraph if my client had failed, or he'd have probably entered a plea, or he'd have been, if they'd found otherwise, there probably would have been no trial. They would probably dismiss the case.
Did they testify to that?
That's what I'm saying.
Or are you just saying that because you wanted it to happen? I mean,
Well,
you gotta
obviously,
have
I wanted
evidence.
it to happen, Your Honor.
I
I'm
know.
not going to
That's what I'm
mislead
trying
you. Of course, I wanted it to happen. I don't think it has to go that far under Strickland. It's got to be a strong probability that the outcome would have been different.
Let me
Doesn't
ask
have
you-
to be absolute.
Mr. Little, the person who defended the case was a public defender.
Yes, Your Honor.
And this person was had tried a number of criminal cases, had she not?
Yes, she had. She was experienced.
Experienced attorney. And so she's now saying she should have done something, right?
Yes, sir.
Which is not too unusual to see somebody later have the attorney. Where is the prejudice that you say, understanding that unless a polygraph is stipulated to go, Judge Murphy has a pretty, extensive order here. Where is the prejudice specifically to show this court?
Well, it's very much like the Dingler case, which is a Court of Appeals case.
Okay.
But in Dingler, there was evidence. There was some DNA evidence that the trial attorney didn't bother to look at, didn't request the funds to have DNA checked. When it actually happened, it showed a difference. Well, in this case, the trial attorney didn't even ask for the polygraph.
But now DNA is going to come in.
It's
One side
scientific.
can't say, we don't stipulate it, so it doesn't come in.
But there are also scientific issues with DNA evidence, and you've got both sides can hash it out. And that's the key point here is you didn't have the adversarial process was not allowed to move forward before the trial. I mean, that's the nutshell of this entire case is the adversarial process was turned up on its side. Instead of, it's sort of like playing football and one side's goal line is 10 feet higher than the other side's. We want to, and it's not a perfect world, so it's never going to be perfect. But the judge is supposed to do what they can to balance that. And in this case, when it is obvious by Judge Murphy's order, he was re-looking at the facts. And that may very well be my fault because I brought so much factual evidence into it.
What would the judge do in this case to make it level?
Well, he shouldn't have said, there's no way I'm going to give you another continuance, because as a defense lawyer in a jurisdiction you're not familiar with, you try to accommodate the judge. That's just what you try to do as a lawyer. And then secondly, when it was clear that this came about, he should have given them a new trial to allow both sides to do the polygraph and let it work its case itself over. As a public policy matter, it's a very small amount of time and effort and money to make sure this trial went fairly.
So you had a trial, and the state and the defense both encouraged the judge on motion for new trial to grant a new trial.
Right, and then the state changed their mind.
And then he wouldn't do it.
He did not grant the motion for new trial. And his order, and I don't want to attack Judge Murphy. He's a very good judge. It's just a matter. It's very easy to flip in these Strickland cases as to whether you're looking at the facts or the fairness of the trial. It really has not a lot to do with the facts. It has to do with whether the trial was fair, whether these things amounted to the prejudice Justice Namias was talking about, to whether there's a strong likelihood that there would have been a different outcome.
But for example, with your continuance, you say she should have asked for a continuance, he should have given one. And what, during that continuance, what would have been found? What would have changed, and why would that have led to a different outcome at the trial?
Well, if she'd have gone to her superiors and asked for a polygraph, she would have had the polygraph.
Okay, we've talked, and then.
She would have investigated these jurors. She would have talked to Pastor Mills.
No, she wouldn't have investigated the jurors. She would have found out about that at trial, right? Whether it was
Had a
right
list.
away or 20 years later, you'd find out about the jurors. You'd normally ask about law enforcement contacts and explore that at trial. You wouldn't go out and pre-investigate jurors about law enforcement contacts.
This is Haralson County, though, Your Honor. I mean, it's very small. And she had Jack Witcher down there and Mr. Wheeler, and they know the county. There's a lot of things that you try to do as a defense lawyer way ahead of time because, for instance, in the federal system, you get jinx stuff 3 days before trial. You've got to anticipate some of these things and move ahead of them before you get standing in front of a jury, before it's too late.
A juror's connections with law enforcement, you're saying it's unreasonable and deficient performance to not take the jury list and go out and do an investigation of that before you just get to voir dire and ask them, you know anybody in law enforcement, and then explore that. You're saying that's professionally deficient conduct, because you're about to make most of the trial lawyers in this state professionally deficient.
That's with all due that's one of the elements that
Okay,
you
well, what's
try.
the
You
next
look at
one?
a jury list.
Polygraph, jury list. What else? should she
Okay,
have
then we
done?
have the investigating. You had 2 reports in the file that were never brought up about the use of accelerant. That would be another investigative thing that would have been looked at.
Okay,
That she should have looked at. She had the reports in her file.
and they showed that there was no use of an accelerant, which the judge says was a fact that was brought out to the jury. You've had the opportunity to, if you wanted to, go hire an expert that would have said something different. And what would experts have said had there been more, had she gone and gotten another expert?
But she didn't even bring.
No, but what would they? We can't just assume that the lack of an accelerant, which is a fact brought to the jury's attention, would have been any different had she explored it more, because you've had the chance to explore it more.
The fact is that the fire investigation report said an accelerant was used. The initial report. And there was talk at the trial about whether it was used or not. And there was no follow-up with that. There was no